Now, on 105.9 FM and streaming worldwide on the WMAL app. O'Connor and Company.
6:36. Call it 6:37. Why not? It's O'Connor and Company here this Thursday morning, 15th day of January. Good morning. Thanks for joining us. 7:05, we'll speak with the Deputy Spokesperson of the State Department. A lot going on there in the house that Marco rebuilt. 7:35, Patrice Onwuka, our very own Patrice Onwuka, whose son had a star turn yesterday in the Oval Office with the president. It's going viral. Quite a moment. 8:05, KT McFarland on Greenland and Iran. That's all coming up. It's Larry O'Connor with Bethany Mandel. Good morning, Bethany.
Good morning. I'm so excited to be here with you today.
Thank you. You know, it's been an hour since we talked about Zohran Mamdani installing bidets in Gracie Mansion in New York. And, well, Jamie Whitten and I are still talking about bidets in our traffic and weather reports. So I just wanted to let everybody know why they might hear references to bidets.
And people can go back and listen to the podcast to hear that wonderful segment that I absolutely consented to.
And while you're subscribing to the podcast, subscribe to the Mom Wars podcast as well at Substack or at Apple or wherever, just everywhere. That's Bethany's little project there. That's very exciting. All right, joining us now, Hans von Spakovsky, recently announced Senior Legal Fellow at Advancing American Freedom. Congratulations on that, Hans.
Well, thank you. My wife was very happy to know that I'm actually getting a paycheck again.
Yeah, really. Last we spoke on New Year's Day, you were like, I don't know, you need any help around the house, Larry? I mean, I'll rake your leaves. What? So, yes, thank you for actually getting a paycheck in. Meanwhile, yesterday at the Supreme Court, a 7-2 decision, it seems, again, like common sense. The Supreme Court determined what now having to do with election fraud lawsuits?
Well, Michael Bost is one of the few Republican congressmen in Illinois that they haven't managed to redistrict out of the state. And he filed a lawsuit claiming that Illinois' state election law, which says we're going to count your absentee ballot, if you can believe this, for up to 2 weeks. If it comes in for 2 weeks after Election Day, we'll still count it. He said, well, that violates federal law. Remember, there's a federal law, several, that set the date for federal elections to be the first Tuesday after the first Monday in November. Mm-hmm. And the trial court there said, you don't have standing to bring this suit. In other words, you have no actual injury, so you can't bring a lawsuit. And unfortunately, the Seventh Circuit Court of Appeals agreed.
Amazing.
And it is. I mean, those are just... they were such dumb decisions, because if a candidate doesn't have standing to file a claim saying that a particular state law violates federal law, well, who would? Right. Anyway, fortunately, yesterday, the Supreme Court, 7-2, issued a decision saying, well, of course, Michael Bost and candidates have standing in this kind of situation, and they issued a very broad rule. Now, there was concurrence by Barrett, joined by Kagan, of all people, in which she agreed in the judgment. But there was a dissent written by, Jackson and Sotomayor, the two most liberal justices, and they basically, they really almost wouldn't allow candidates ever to challenge state election laws.
Yeah, it's like if a candidate doesn't have standing in a case like this, who does? A real quick follow-up before I throw it to Bethany. Did they make any opinion on the merits of the case? Or was this solely based on who has standing? Because, I mean, it seems like a no-brainer to say, yeah, Election Day is Election Day. You don't take mail-in ballots 2 weeks later.
No, they didn't issue a substantive decision. They basically said, no, Bost, you do have standing to bring this claim, and they sent it back down to the lower court. But that issue is already up before the court in another case they accepted called RNC versus Watson, because the Fifth Circuit U.S. Court of Appeals already held that Mississippi's got a similar law, although they only allow 5 days after Election Day. The court took that case, and so they're going to decide whether all these states that allow absentee ballots to come in after Election Day, whether they're violating federal law. So even though this is a great standing, a decision on standing, the substantive issue, it's already up before the court in a different case.
Okay.
Have you looked into, as way of background, I ran for school board here in Montgomery County, Maryland, and I'm a little bit of a truther, just a tiny, tiny, tiny bit about the election results, because the early voting and the day of voting, all of those votes went one way. And then after the election, all of the ballots that started trickling in after the election went a very different way. I lost, but I was losing considerably worse with the ballots that came in after the election. Have you done any research to indicate, like, was that experience of mine, my personal experience, is that an anomaly, or do votes that roll in after Election Day tend to swing in one direction?
No, that's very suspicious. All the research that I've done, and I've been doing this for 3 decades, are that when a candidate wins, their percentage of wins tends to be the same, whether it's on Election Day, early voting, or absentee ballots. In fact, in absentee ballot fraud cases that I took a look at, a key indicator was that the absentee ballots votes were totally lopsided in comparison to those other votes. That's usually very suspicious.
Oh, interesting.
We're speaking with Hans von Spakovsky from Advancing American Freedom about yesterday's Supreme Court decision granting candidates standing to sue over ballot counting laws and other election fraud concerns. Hans, assuage my concerns, because I see Mark Elias looking at this saying, "Oh, game on, let's go. He's found a new profit center now." Can Democrats exploit this? Now, will Democrats tie up elections in court, weeks and weeks and months after Election Day, trying to fight these things for no reason?
Well, yeah, but they've already been doing that. And I will tell you, having watched election litigation across the country, that liberals and Democrats have always had a very lopsided advantage. And what I mean by that is judges almost never say that liberal groups like the NAACP, the ACLU, the League of Women Voters, they almost never tell them, "Oh, you don't have standing to bring claims." The people that they always reject always seem to be conservative.
Yeah. Also, real fast, Hans, correct me if I'm wrong, this allows candidates to start challenging these laws before Election Day, which is critical, right?
Yeah, it absolutely does mean that. And like I said, it's very important. I tell you, if the Supreme Court rules against these kind of state laws and says, no, absentee ballots have to be in by Election Day, let me tell you, that will be one of the biggest steps to cleaning up the election process across the United States that we have seen in decades.
We can only pray. Thank you, Hans. Appreciate you as always, and congrats on the new gig.
Larry, Bethany, thanks.
Thank you.
644.